So, so some of this, there's a whole lot that can be said about land trusts. And in this half an hour, I don't have enough time to really do more than scratch the surface. So what I'm trying to do, is going to try and do in this half hour, is hit some of the highlights. Some of the things that I think people find interesting or people really kind of need to know. And so while I'm sort of saying that to start out with, is that a lot of you probably already know some of the real basics about this. And so hopefully I can share something with everybody that you may not know, but we're going to get started. So one of the things I want to start out saying is there's a difference between a land trust and a personal property trust. And we tend to get them mixed up when we're talking about kind of real estate. So land trust, by definition, holds a piece of real property. Okay. So if you are deeding a property itself into a trust, it's a true land trust. But if you are deeding or handing over the interest in a piece of property, so like if you own a property in an LLC, it's a company, not actual piece of property. So in those cases, what you're actually doing is a personal property trust. And those things get confused a lot. And one of the things we're going to talk about here, just, well, maybe not this time, but keep that in mind. In fact, most of the stuff that we are doing when we are dealing with, quote, land trust, it's actually a personal property trust, even though it is holding an interest in real estate. So a land trust holds title to real estate. And a personal property trust is for holding paper. E.g., if you have a lease with an option, if you have ownership shares in a multifamily property, that's actually a piece of paper. And so that's a personal property trust. The other thing that is talked about a lot with that I hear from people who talk about property land trusts is that they are offering asset protection, that they protect the asset. And that is blatantly not true. And so if you walk away with nothing else from this, a land trust does not offer asset protection. What it does do is offer privacy, which is not to be sneezed at. But actual asset protection comes from things like LLCs. So if somebody could go into your, get your trustee to say who is the beneficiary of the trust, and they will, if they're compelled by a court, then if you are holding something in your own name in this land trust, everything you have is vulnerable. So I think that that we need to make sure that we understand that there's a lot of benefits of land trusts, and so I believe in them, but they are not for asset protection. So what we typically do is layers. You have a land trust, and the beneficiary of a land trust is actually an LLC. And I think I have a slide where I'm kind of showing that towards the end about how that really looks, right? So there are not a lot of title companies. They're not maybe a lot of attorneys even who really understand land trusts. And so when we go to need to set up a land trust, it really is important that you find an attorney, Joe, who's on the call today, to get them to set up your land trust, at least the first one, right? So land trusts are great in conjunction with entities, and they do make it hard for others to find out the true owner of the property. And so we already talked about that there's other benefits. So let me kind of see if I can. All right. So this is just kind of an overview. The best protection for someone who owns a property is an entity, such as an LLC. And in most of the times, I think most people are in agreement anymore that the best way to hold property is an LLC because it can be taxed as a corporation or a partnership. All right. Before you put something into a personal property trust or a land trust, you really need to have the entity in place. So that comes first, followed by the entity. I mean, followed by the trust. So land trust should be seriously considered if you own a number of houses in a single LLC. So one of the things, so for instance, I have a partner, so we still have some single family properties. And we have a couple of LLCs in residential, each of which are holding 25 properties, or so we limit things to about 25 houses. But given the price of houses these days, 25 houses in one LLC can really open some vulnerabilities. Obviously, if one is sued and somebody wins the suit and gets past your insurance, then all of those houses in that LLC are at risk. So one way to think about mitigating some of that risk are to have the LLC, which is not disclosed in the property records, but you have land trusts and you name each of the land trusts differently. And so it's hard or if somebody wants to try and find you, who owns what else, to find out other properties that might be in that same LLC. Now, it's not meaning that they can't do it because there's some pretty clever people out there, and there's more and more things that are having to be disclosed these days, right? So, basically, the more properties you have in one LLC, just by the nature of it, the higher the risk is. So it's easier to put them in land trusts. And one of the things I'm not going to be able to talk about really today is how you name land trusts to try and avoid everybody kind of seeing that, that you're naming all your land trusts the same way, which opens up clues that it's one ownership. But we hopefully will come back to that. We're down the road here. We're going to do actually a 4-hour webinar on land trusts, and I can go through some of that then. All right. So let's talk. They're created by two events. A grantor enters into agreement with a trustee for the benefit of a beneficiary. So after this slide, I think I have a picture, hopefully that'll help a little bit. The titling of the real property. So you actually have to deed that property over to the trustee of the trust. But they are only holding that trust in their capacity as the trustee, and they are supposed to only be doing that for the benefit of the beneficiary. Having said that, because the trustee actually has legal title to the property and equitable title, they could sell it if they chose to do that. That's one of the reasons they say when you're finding a trustee, find somebody you trust. It's also one of the reasons that when some of the bigger, more sophisticated companies out there will have two trustees, or they will have a trustee for one part and a trustee for the other. So it's not unusual, for example, to have a trustee for making decisions and kind of running things usually, and have a backup as an attorney who would handle anything legal. So you have some ways that you can set up in your trust documents such a way so that it's harder to sell something or make some decisions without input from the beneficiary. A land trust is actually a type of a revocable living trust that holds real estate. Right. Once a trust is formed, you have to fund the trust with a change in title. So you can have a trust out there, but if the property isn't deeded into the trust, or your ownership interest isn't deeded into the trust, then it carries no weight. There is no effective trust, and that's true of all trusts. Once you form it, you have to fund it. All right, so I'm not going to go into the history very much here, but way back when trusts first started, it was Standard Oil kind of thing, where they set it up thinking that you could have a trust last forever, generation after generation after generation. And because of a whole lot of the issues that happened with some of these, robber barons back there, the government, that was some of the first antitrust stuff that came about. So the practical issue now, or the practical result from that, is that trust can't last forever. Most of the time, it's about 20 years. And in your trust documents, there will be a sunset, should be, of when that trust ends. And you need to figure out how to do that. And if you don't end it, chances are somebody's going to do it for you. All right. So I think that's all I want to say about that. So here's what this kind of looks like. Before you put this in a trust, you have the title, and it's generally in your LLC, LP, corporation. And then the owner, whoever owns that LLC or is a beneficiary of that LLC, basically has full ownership rights. They make the decisions, they're the beneficiary, and they are the legal and equitable owner of that property. So what you typically are going to do is have a grantor, and in most cases, that is generally the person who owns the property, is going to put that into a land trust. And they are going to assign a trustee, and the trustee holds the title, and it takes actions only at the direction of the beneficiary most of the time. The land trust then is holding that that the land trust holds, or actually it's a personal property trust at this point, holds the LLC. And the LLC has the beneficiary of the LLC. So instead of having the beneficiary name directly from the personal property trust, it goes Land Trust LLC beneficiary. Is everybody understanding that? Okay. So the ownership rights in a trust are actually divided between the trustee and the beneficiary. The beneficiary still has all the benefits and has some control. And we're going to talk about that in a little bit here, right? So these are just some of the key kind of flow of how this works. The trustee has both legal and equitable title, and the beneficiary has no interest in either. So if you own an apartment building, if you own houses, the trustee actually owns the house. And you have all the benefits. So you have the incomes, you can make the decisions about it, etc. In most trusts, the trustee has no duties other than to convey, pledge the property as collateral for debt, or deal with the property as directed by the beneficiary, and that's in most states. The trustee typically, here's this 20 years again, has the duty to sell at public auction, any property remaining in trust after the stated period. So you want to have, so what that tends to mean is that if something happens to you and you're a beneficiary is changed, they need to keep track of when this trust ends. Otherwise, they can find this property sold out from under them at a public auction, which is never good for the property. Another typical thing is that the beneficiary, e.g. you, if you used to own this property, indemnifies the trustee for expenses or outlays. So it is still the property, still you, that is making those payments. And you're also generally indemnifying them from suit or other kinds of things if something happens to the property and you're sued or something else. So the trustee is generally not held liable. Okay, so I think you can read that all of the rights of use belong solely to the beneficiary, and I just listed some of them there. Since the beneficiary doesn't own the property itself, the rights are actually in a personal property trust. So if you are the beneficiary, it's actually something on paper. And so it's a personal property trust. Most trust agreements, and we're not going to have, I'm going to talk here just 1 minute about trust agreements. But most of those trust agreements basically forbids the disclosure of parties or of who the beneficiaries are, the terms of the trust, etc. Right? But if somebody is sued, the trust is sued, and it's generally the trustee that is named in the suit, and a judgment is forthcoming, the courts will order the trustee to disclose the beneficiary, and they are not going to not do that. I mean, the last thing a beneficiary wants to do is to get themselves in trouble with the law, and I wouldn't expect them to. So some gurus say, well, if it looks like you're going to be sued, just change the trustee. Well, it still has to be recorded to be a legitimate trust. And if you already knew that you were going to be sued, you can find yourself in a lot of trouble for trying to knowingly avoid somebody else's rights. I have seen a number of trust agreements that are on the internet or that some people talk about using, and they're 1 or 2 pages. They are sorely inadequate, most of them. That's why I'm going to say for sure, the first time you do a land trust, go find a good attorney who has use of that, who knows how to do that in the state in which you are located. Doesn't have to be where all the properties are, but where you reside. And we're going to talk about that in a minute. And have a decent trust document put together. So my land trust run 18 to 20 pages. Once you have one, then maybe you can figure out how to do the others and just change some of the wording here and there. But it is worth making sure you have a decent trust document if you really want it to have privacy and to help you out. So that was my comments about that. All right. So let's talk here for just a minute about ownership. Ownership interest, right? So for an individual, if there is death or incompetence of an individual owner, the legal system can tie up a property while someone is appointed by the courts to proceed. But when you have a land trust with a trustee, this generally is not a problem. So your beneficiary rights continue, and the trustee continues to perform as directed in the trust agreement. Same thing with a personal bankruptcy. A lot of times in personal bankruptcies, if you have owned property, the bankruptcy can hold that property, your income producing properties, if they are not in an entity. It can hold them and not pay certain things or do certain things with it. Whereas if you have a land trust and move into bankruptcy, business bankruptcy or whatever, then the bankruptcy trustee just steps in and still has the responsibility of managing both the benefits and the burdens. So let's talk for a minute about multiple ownership. When multiple person or entities share ownership outside a trust or entity, dealing with the title can be a challenge because there's more than one person who has ownership interest. And conveyance frequently requires, before you can sell it or do something, of each owner. If it's in a land trust, it protects the title of the property.
Hey, Nicole, we're not hearing you. Hello?
I cannot hear Nicole either.
Okay. Hey, Nicole, we're not hearing you. She's not muted, so that's
Maybe a small glitch.
maybe she's having a storm like us. So. Anybody have any questions or comments while we wait for her to come back? I know, Joe, you had one. I don't know that I can answer it, but
More just a comment about, I guess, just one small thing. I mean, the attorney who would be preparing the trust, it doesn't have to be physically located in that jurisdiction where the property is, but if you're gonna, it may just be, might just leverage their expertise and knowledge to draft the deed as well to title that property into the trust. So the attorney should very least be admitted and licensed in that jurisdiction where the property is, because if they're going to be recording that deed, I know at least in Maryland, it requires a signed certification from that attorney who prepared it, just to say that this attorney is admitted before the courts of Maryland. Jurisdictions may differ on that, but I would just say that as a good rule of thumb, that attorney preparing the trust instrument and the deed should be admitted in that state where the property is. Just because when they draft the deed, they'll also just know what statutory references to put in there if there are transfer tax exemptions on the table to take advantage of.
gotcha. Yeah, and we've seen that happen. Just getting that certificate in a couple different states. So, does anybody in here use trusts, or Joe, do you have any other tips?
I would say, on the point of how long the trust can last, I mean, the person creating the trust is free to make whatever term they desire, though you're able to just have that event to terminate the trust be that person's death, whoever's creating it.
Right.
Because at that point, the trust goes from revocable to irrevocable.
Okay, that makes sense. Definitely makes sense. Because we've heard 99 years is but this is
Right. Again,
I'm back.
states vary.
Oh, there's Nicole.
What were you saying, Joe?
I was just making a few brief comments. I know you suggested that the attorney doesn't have to necessarily be in the state where the property is located. I mean, I would suggest at the very least that the attorney be admitted and licensed in that state. Basically, just because you're going to take advantage of them being able to prepare the trust instrument and record the deed that retitles the property into the trust. Just plenty of states that require when you're recording a deed to have a certificate attached to it signed by that attorney saying they are an attorney admitted and licensed to practice in that jurisdiction. And if they are admitted in that jurisdiction, then they should know what statutory references you should put in the deed, just so, if you're eligible to take advantage of local transfer tax exemptions, then the attorney should know how to put the magic words in the deed to do that.
All right, that's a good point. I was going to bring up a point about successor trustees here in a couple of minutes, but you make a really good point. So I have a lot of land trusts with properties scattered around, and I've typically used the same attorney, but I will take your advice because you know better than me on this. So, all right, I'm going to move on here to this next. Pardon? So kind of avoidance of issues. So these are just a couple of extra things that I think land trusts can do that most of us don't know about. So, and one of those are kind of marital issues. So laws in certain states can require that a spouse also sign a document concerning real property where they aren't even on the title because of community laws. Titles of real estate held in a land trust is usually not subject to community property or other marital rights of the beneficiary in most states, but there are some where it is, where the marital benefits continue. And so you would need to check that out at the state. So what that practically means is that documents dealing with the title can only be executed by the trustee. So it allows for quick and unobstructed dealing with title to a problem, even if there's a divorce or other strife. deadlocks and partition suits. So think about somebody who is who owns a fairly good sized piece of property, and there are 5 kids and they all want to do something different with it. And it can get locked up. So what you end up doing within a trust is that the trust document is what guides what's going to happen. And that typically avoids some of the issues with estates and other things like that. And so that is actually one of the reasons trusts are used a lot, is that it avoids some of those family issues and allows for the trust or the holdings to continue without exposing it to family problems, right? And so those are a couple of the benefits of trusts that I'm not sure people kind of can think about, but has some real benefits. So this is the other one I want to talk about a little bit more, which is transfer on death. Okay. So for a land trust, if there is no successor beneficiary, then the beneficial interest of that person who died is part of the probate interest and is passed on to the heirs of the deceased. So it ends up, so if they have a living trust or other kind of trust that this land trust is in, then that trust takes precedence. But if you have a will say, then this land trust gets caught up in all of the issues that go along with a probate to a certain extent. And so there's things we can do where we can avoid a lot of that. And it is really worth looking at here. So in land trust, the name successor, so if you have a successor beneficiary named in the trust, then that continues to hold the beneficial interest or can direct the trustee to transfer the property to him or somebody else, right? If there isn't a successor beneficiary, the beneficial interest is probated as part of the estate and is treated as personal property and is subject to the payments of debts and dispositions the same as other personal property. Okay. So if you have, all of us who are in real estate, I think, tend to know that one of the ways, one of the things that gets people in trouble a lot, and why probate becomes such a good way to find properties, is because the property gets hung up in probate and it's hard to pay mortgage and other bills and stuff if something is hung up in probate. And this avoids a lot of that, right? And a land trust can be used to control the disposition upon death and only requires that the trust agreement provides that upon death there is a successor. Doing this avoids probate process for this property, right? So the other reason to have properties in trust, now remember, once you have a property in the trust in an LLC, it is now a personal property rather than an actual land property. That has a lot of ramifications in death cases as well, because, and it's one of the reasons I have some land trusts as well as, basically everything I own is in a trust. Because if you have properties in more than one state without a trust, this is important, folks. without a trust of some kind, land trust, living trust, something like that, then because you actually own a piece of property, then you actually end up getting to open probate in every state where you own a property. Doesn't that just thrill everybody? So, if it's in a land trust, right, what you are actually owning, it's actually personal property. Personal property is typically deemed to be under the auspices of the state where the deceased lives, where their residence is. So if you have a trust of some kind that is funded, land trust, revocable trust, whatever it is, then you avoid having to open probate for properties you own in every state. And since I own properties in 11 states and 2 or 3 countries, that becomes an issue for me, as you can imagine. So trusts are your friend. All right, so let's talk about this. I want to show you what this looks like. And I'm using James. I think I saw that James is on, got back on here, but maybe not. So while James is alive, he has this in a land trust and he has the beneficial interest. James names in his trust documents a successor beneficiary, Isabella this time, right? And this person is named. James dies. Nicheole gets really ticked off at him one day and goes out and shoots him. And he dies, right? So, but he has a named beneficiary. So now Isabella steps right in to that beneficial interest without probate, without needing to do anything, because it is already set up in the trust, right? So you may have to, and because remember, the trustee and the name of the trust is what is recorded, and the trust documents have the beneficiary named, right? Then you may not have to do anything. Certainly in the land records, you may have to report under this new, the IRS wants to know everything you do law. But we can ask Joe about that a little bit later. So I think that's kind of the points that I really wanted to make. Those are just kind of hitting some of the highlights. There's a whole lot of other things. So I want to just remind you that we have a course online that if anybody wants to learn more about multifamily, it's about 60 hours. And even if I say so myself, I think it's probably the best thing out there that teaches you how to buy commercial real estate, as well as how to raise money legally and how to manage property managers. If you have questions, you can send questions to support at passivecashflowforlife.com, and that is our that passivecashflowforlife.com is our website. July 20th, we were going to do a webinar on land trust the end of this month, but it's gotten put back for a couple of reasons. And so the next webinar we have coming up is going to be taught by our favorite people, Jane and Sharon, and they're going to talk about mastering virtual real estate investing on July 20th. And the cost is $27 for the rest of this month. And you can see where to go to sign up, and hopefully somebody will put that in the notes or in the comments. The only other thing I want to say here is that we all of these are recorded and they go up on our YouTube channel, and that is our YouTube channel address there. And this one should be up by the end of the week and posted. And at this point, I'm going to stop sharing. And I am going to turn it over for questions. And I would like to hear, particularly if Joe and Nashra have any insight. Joe, for those of you who don't know, is kind of an attorney who specializes in wills and trusts and stuff like that. So he has a lot of knowledge and ability here. Hey, Joe,
Hey there.
any comments, other things that you think are really important to add? Any questions, anything? If other people have questions, you can ask Joe too. I'm putting him on the spot here. He didn't know I was going to do that, but he's a good guy.
Yeah, I know I have my prior comments about who the attorney is preparing some documents.
Okay.
And I was just making the point earlier that for the term of the trust, I mean, you can just do it for your life. It's really up to the grantor, the person creating the trust, how long they want to set it up for. Of course, it's limited. It can be limited by either state statute or common law, because they have some rather archaic rules as to, how much time do you look to figure out whether an interest in property passes to someone else or fails to pass to somebody else. Though usually a safe bet is the measuring event is somebody dying.
So how does that play out then if you have successor trustees in a trust document?
For successor trustees,
So if normally a trust ends when the beneficiary dies, but in the trust document, you have a named successor beneficiary, does the trust continue on through the life of the successor beneficiary?
well, if the trust then calls for the assets to be distributed outright and there's nobody else, that's the one person getting the assets, then, and assuming the land trust only carries the one asset, then the trust is in effect empty and terminated by that point.
And if it doesn't call for the property to be disposed of, but to continue acting on?
I mean, it can continue to be held in trust for that successor beneficiary for their life. I mean,
Okay.
there are estate planning techniques that employ a type of trust known as a dynasty trust, where the assets in that kind of trust, it's more for personal property, where the assets just kind of percolate generation after generation, where new trustees step in and grandchildren and further generations down can take advantage of the same corpus of assets that were set aside for them. I know I've run into many in practice where trusts set up in the 40s or the 50s or the 60s are on the third or fourth generation.
Okay, good point. Thank you.
Hey, Joe,
Other
what
que-
if, yep.
Go
Hey,
ahead.
Joe, what if and this might be a hard one. What if the trustee disappears or dies or whatever, but nobody knows where the trust documents are?
I mean, then you kind of have to rely on having copies and good record keeping done, because if you have copies, at least you can petition a court to say this is the best approximation of what the creator of the trust has intended. Then you would have to try and sort of convince the court that that was the case and to follow the terms of the copy that you have. It's almost like a will contest where dueling copies of wills get thrown around at the court and you're trying to convince them which one's the correct one. But usually, the attorney who drafted the trust should have a copy of it, and and normally you're able to track them down if the original is lost.
Okay, and if the person created the trust, then there's no copies, and then there's properties in the trust.
I mean, then you're left with going to court to try and approximate what the terms of the trust are. You have to use sort of external evidence to try and figure that out. I haven't run into a situation where a court kind of just throws its hands up and says, you know what, we're just going to try and probate this. Because once you title an asset into a trust, that would effectively get you out of probate. Even if you have a situation where all the beneficiaries fail, they're either dead or cannot be located, then you kind of default to state statute on how the asset is to be distributed if there's nobody around.
Gotcha. Thank you. Anybody else have any questions for our resident attorney or Nicole? It's kind of cool having an attorney here.
Yeah, it is, huh?
It's sort of like
Appreciate you.
it's like it's good to have a lawyer in the family.
Yes,
Right.
it is. Yes, it
Absolutely.
is.
Oh yeah, my parents take full advantage of it.
Well, maybe we should follow along behind your parents and take full advantage. Maybe not.
Well, I can't marry all of you.
That's true.
I can-
Good
But
one.
Nicole, I
How-
would like
how
to
about-
apply to be
are
your
you-
goddaughter. I
Are
would
you
like-
open to adoption?
Yes, I would like to apply to be your goddaughter. If I was actually just telling Joe this. I was like, what could I do?
All right, so anything else? So there's a lot of other things that are interesting about land trusts and other kinds of trusts that, I think they're pretty, once you start having some assets, trusts are really important, I think, in your long-term strategy for generational wealth and making sure things are protected. So I know when I got started in real estate 25 years ago, I didn't have any idea about them. I didn't have any idea about a lot of stuff. And so I had to go back and create some stuff. So it really, I think, is beneficial when you're getting started to know that about these things and to sort of have that in the back of your mind as you start acquiring assets. And that's where having a lawyer in the family who knows how to do these things, that where you can go ask somebody to help you kind of get started on some of this for a fee. Because
For a
that's,
fee.
pardon?
For
Billable
a fee.
minutes. Billable
Yeah.
minutes. Hey Joe, do you go one way or the other with trust or LLC? Or you, because some attorneys hate trust altogether, some like them.
I mean, the LLC has the advantage of simplicity of, you can use a lot of the same forms over and over again. Though I think I can see where a lot of attorneys can get confused with land trusts because some of them might want to just try and go for the asset protection and try and get you to go into an irrevocable trust, though I certainly would not recommend that, just because if it's irrevocable, you lose control over the terms of the trust, and you almost always have to name somebody else, an independent party, as the trustee. So you're definitely going to lose control there. I mean, if you want to have someone work in tandem with you, to be sort of almost not necessarily as a successor trustee, but trusts often have roles cut out for people called trust protectors. And they can step in to make modifications to the trust. They can step in for certain other matters, and to act if the grantor is incapacitated. And that's just one example that you can just explore how flexible a trust can be, where sure, the person on the title is named the trustee, but there's another person in the wings acting as a trust protector to sort of assist the trustee in administration of the trust.
Okay, awesome, thank you. Anybody else? Questions? Comments? Anybody want to hear more on trusts? I know we do.
It's a very powerful tool, but you really have to know what you're doing to utilize it to the best of its ability. And Nicole is amazing with that. She's used trust for years and years and years, and she's the one that you would learn from. So I wouldn't miss her upcoming webinar on trusts.